Hello and welcome back to another episode of the Practical Planner Podcast. I am your co-host, Thomas Kopelman, head of community at wealth.com and co-founder of AllStreet Wealth. Here with me, as always, Anne Rhodes, chief legal officer of wealth.com. And excited to be back with you. And I'm excited to do part 2 of an episode that came out, I guess it'd be about a week and a half or 2 weeks ago. So for everybody who did not go watch that episode, I would definitely do it because it's, I would say, a building block to this episode. So what we really talked about in the last one is whether you should, your business should be owned by a revocable trust. And I think we had a lot of good points about that, but I don't think there's any way to hit on this point enough without going into the whole irrevocable side. But obviously, I think like 101 is revocable, 201 is irrevocable. So I'm excited to talk with you about this.
I'm very excited to speak with you about this, Thomas. When I was a practicing attorney, was out here in the Bay Area, I had a ton of startup founders who came in through the door. They had businesses, they had stock or stock options, and what to do when they wanted to do, revocable trust planning or, very interestingly, irrevocable trust planning, right? And so we'll talk about some of those objectives and then just give you some pointers, I think, about legal terms and legal issues to be on the lookout for.
Let's just kind of first talk about why would anybody even want to own, whether it's their business. I think we can distinguish the two, but both are important, whether it's your own business or maybe you're an early employee at a private company. Why would somebody even want to do this?
So I think the objectives kind of, with all irrevocable trusts come down to 3 main objectives. One, you have kind of control planning. And so this is particularly when you're no longer around and you're worried for the operations of your business or the economic rights of your business and who gets to, enjoy those economics. So control is number 1. Number 2, I would say, is asset protection, right? Particularly if there's a business involved, whether or not it's reachable by a creditor. That's number 2. And then lastly, and very interestingly, because there's so many types of irrevocable trust structures that are in place for this, would be tax planning, right? So at this point, you have a business where you can get some advantages from an estate tax or generation skipping transfer tax, or even a capital gains tax perspective. And there are some really interesting techniques that you can employ to be able to capture, some of these tax advantages. So that would be the third reason: control, asset protection, and tax planning.
Do you think we go through one by one each one and kind of explain what that means? So I think starting with control, what does that really mean?
Remember that irrevocable trusts can be formed at various points in time. So the first thing is, during your own lifetime, if you're forming an irrevocable trust, it's unlikely because of control reasons, except if, let's say, as you're transferring a lot of wealth to somebody for either asset protection or tax planning purposes, you're also saying, hey, I don't want my beneficiary to just have like unfettered access to be able to enjoy these assets. And so I actually want to put in place, a trustee who knows what they're doing, or, standards for how to distribute the money, the economic rights that the trust receives to that beneficiary. But remember that your irrevocable trust can also be formed at death, right? So this is where you're no longer around to even direct anything. And so think about the marital trust that you may be putting in place and how you may want to have a marital trust owning your business for control reasons. And this can be for, all the normal reasons why somebody might do a marital trust, including having a blended family, where you're saying, at the end of the day, if the stock in my business, is still around, it's doing well, and my spouse has, enjoyed the income from that business during their life, at the end of the day, I don't want my spouse to disinherit or, somehow have a say over who else gets, this business at interest. And so I wanted to go to my heirs, who I consider to be my second level beneficiaries, who might be children, charities, whatever else, is really important to you. So you do want to provide income to your spouse during their life, but at their death, you're saying, hey, I want control over what happens to that asset.
I have a client, Kate, I'm working on where he's actually the trustee of a trust for one of his co-founders who happened to pass away. And so now he's managing it for his kids. I can totally relate. And it makes a lot of sense, right? Super wealthy people, I don't think you always want to say, here's 20, 50, $100 million and you're, in the middle of college. I mean, I think we can all attest if you were 20 and got $20 million, you'd be living a pretty fun lifestyle.
Oh, for sure. I mean, I've worked with clients here in the Bay Area who sold their companies for, billions of dollars, those unicorn startups. And initially when they did the transfer, and this is one of the things that's so strange, right, about doing like tax-based transfers, you're trying to capture when the stock is like not worth very much, hoping that like outsized appreciation is going to be captured outside of your taxable state. So like in that irrevocable trust, but you kind of don't know how much that might be. We've had founders who, initially thought, projections with their financial advisors, with us, I'm going to be forming like a $20 million trust for a kid. That's a really good trust, for one child. But then it turned out it actually like the stock was, IPO'd and it was crazy. And it was like $100 million trust, right? So you definitely want some control over how your descendants will spend that money.
Okay, let's go into tax planning. I think the most fun part about this conversation, and in the conversations I'm normally having, it really is geared around tax planning, really both estate planning, but also, QSBS stacking, a few different opportunities there.
Exactly. So on the asset protection, I'll just touch on it very briefly. Really, we're talking about asset protection for whom, right? It's the beneficiary can be you yourself. You have a big debtor creditor issue happening and you're like, oh my gosh, how can I protect my business while I'm still alive? Those planning opportunities are actually very few and far between, especially if you're based in certain states, right? So like California judges, for example, don't look very kindly on you trying to like squirrel away your own assets by forming a trust. But there are like offshore opportunities and certain things like that. So sometimes asset protection, your own asset protection comes into play. But then there's like the general version of asset protection, like spendthrift trusts, where you're just saying, hey, I'm forming this trust for my kids, right? This is like the startup founder forming a $20 million trust for their kid. There, you just want the basic spendthrift provisions to apply so that if your kid is in a hit and run or a divorce situation or something like that, that trust is protected in as much as possible by the law. And that's much easier to form, actually, and much more respected by the law.
Asset protection is something that advisors don't think about enough. And, beginning of asset protection for a lot of the lower wealth clients really are just, the right insurances, emergency funds, LLCs set up. But then for higher net worth people, they're bigger targets, right? So it's more umbrella insurance. And then it's thinking about, okay, we have so much in assets, like let's get these out of my name. So if anything were to happen, I'm more so protected. And I think that, if you're working with or people who have a lot of wealth, you really have to go into the asset protection side because they've made it, right? Financially, they're fine. Tax planning is impactful, but the biggest risk they face is lawsuits or things that can take away tens of millions of dollars from them.
Exactly. So now we can kind of touch on tax planning. And there are kind of two big buckets of taxes that you worry about. There's the estate and generation skipping transfer tax. So I call those transfer taxes versus your income tax. And I know, Thomas, you don't like just using income tax as the umbrella term, but capital gains planning specifically. So we can touch on those. There are so many strategies involving trusts to do this kind of planning. So a couple of trust names that might be familiar to you, just to kind of think about, right? So in the first area, we're doing estate tax planning or generation skipping transfer tax planning. You have to realize that actually the trust is going to be paying potentially more in income taxes than the beneficiary had they received the assets outright because of the way that the tax brackets are structured for a trust versus an individual. So that's the first thing. You're not doing this for income tax planning. You're really doing it for, preserving wealth over generations as that asset appreciates more and more and more so that it never ends up in the taxable estate of any future family member. So that's what you're doing. So think dynasty trust planning, right? And dynasty trust can really be embedded in all sorts of other techniques. So let's say, for example, you and your financial advisor and a CPA decide that like some sort of structure like a GRAT would be really nice to have. You're going to be making a transfer of an appreciating asset without using any of your gift tax exemption, right? So this is a zeroed out GRAT. And then you're saying, okay, this GRAT is going to last 5 years. and I'm going to receive an annuity back. But whatever is left within that trust, so that's the appreciation, right? You're hoping to beat the annuity. Whatever is left in that trust goes to my beneficiaries. So think about the fact that you're doing this for, some tax reason, but then you're saying, okay, my beneficiaries could just get that outright in their own names, right? So like the GRAT terminates in 5 years and you, Thomas, as my beneficiary, just receive whatever's left in the GRAT. But that ends up in your taxable estate, right? As my kid or my spouse or whatever. And so you can say, actually, I'm going to embed a dynasty trust within my GRAT so that when my GRAT terminates in 5 years, it pours into this continuing trust that's perfectly structured from a generation skipping transfer tax perspective so that those assets stay outside of the taxable estate of you, Thomas, as my beneficiary forever. And when you pass away and my grandkids or, your kids are getting the benefit of that trust and the appreciation of that stock in that business, it's also outside their taxable estate.
I just have a question on that. So for like this GRAT example, right? You talked about high appreciating assets or what makes sense. How important is liquidity in planning with GRATs? Like, is it something that somebody would want to put a privately held company that you can't really sell from, right? Because that growth happens, but how do you donate those shares from the growth?
So this is where, very importantly, when I said, for example, if you put together a GRAT, you have to do it with the advice of your financial advisor, with, a CPA potentially, is to make sure that the cash flows kind of work out, that you're picking the right asset to even stick in that GRAT. Because a technique like a GRAT, and we can spend a later episode like really honing in on that particular strategy, is that you want the asset to actually beat a certain default rate that the IRS has set, where that annuity that comes back to you, like if you set up a GRAT that fails, there are many reasons it could fail, but one of them is just that it didn't appreciate the way that you expected it. And so then actually you haven't transferred anything by doing the work. The annuity just captures all the growth.
But a founder I know who like we've put courses into their community is working on a product that will be able to take like basically like an index, and they will be able to create like 500 GRATs for a client, and every one that goes above the hurdle will go there, and then it'll restart the clock and redo them, kind of like direct indexing, which is really interesting.
But in any event, yes, liquidity matters a lot, what asset you've picked. So that kind of strategy you need to kind of put in place for a specific objective, but the end goal is kind of just an estate tax or transfer tax planning strategy. So that's the reason why you might want to stick your business into an irrevocable trust. Then we have capital gains tax planning as well. And here I'll give you two kinds of trusts that exist. And it's to do either federal level capital gains planning. And so here we can talk about QSBS stock and having non-grantor trusts to do that kind of QSBS stacking that you were just talking about. And then the second type of trust that I wanted to talk about is actually at the state income tax level, where you can have something called an ING, a DING, and NING. So those stand for, Delaware Incomplete Gift Non-Grantor Trust, ING, D-I-N-G.
If you live in California, right, anymore, those just kind of like last year got written off.
Yeah, exactly. New York, California.
Well, this is the perfect example, right? If you want to minimize California state taxes, leave, because you can't do that. And also QSBS is not recognized in California either. So
yeah, so that's why it's a federal level kind of planning and not necessarily state level. Yes, the FTB California, it has a deficit, and so it needs its tax money, and has gone very clever about, curtailing some of these strategies. But it works in some other states. So
yeah, it's funny because I feel like to me, like QSBS is like one of the most well-known tax strategies. But I was like just sat down with a prospect who he owns two businesses that will do like 160 million in revenue combined this year. He's like, my CPA doesn't know what QSBS is. So apparently it's not. So for people that don't know, QSBS is basically a way for small businesses, for the owners of it, to be able to exclude capital gains from it. It's basically like 10 million or 10 times your cost basis, whichever is greater. So I think sometimes people think it's just 10 million, but I've seen examples of people getting significantly more, but you also have to hold the shares for 5 years. this also has to be at the same time the company has less than 50 million in assets, not revenue. And so it's a strategy that can be really impactful. Like I have a client who, he probably has like 5 million of QSBS eligible stock, which is really, really nice. Obviously, he lives in California, so still pays the 13.3% capital gains there. But the rest of it, you have the ability to choose to sell whenever you want to, not have to like make the tax decision. But then you can take this a second level, right? And so it's each entity. And so you can do this through various trusts and end up stacking significantly more QSBS eligible stock, which is where this irrevocable trust side of things starts to really make sense. Obviously, maybe if it's 5 million or 10 million, that's probably not the part where you start to go above, but think about the early, executive at SpaceX or some company that's really, really big. You might have 50, 100 plus $1 million of stock, where stacking these could be, the difference of a lot of dollars at the end of the day.
I'll give you an example too. I worked with a family, so some startup founders, and basically in order to stack the benefit, this is, a 10 million start for free from a capital gains perspective, and to try to multiply that effect, they set up, I think each founder set up 4 trusts. So think they were young. So they had kids, like 2 kids each or something like that. And then like parents, they were like, how do I, find enough beneficiaries to make these each trust kind of slightly different so that I can get the benefit of the stacking? Because if each trust is too similar, the IRS kind of just like merges them into one, and then you don't get the multiplying effect. But anyway, so they were just like looking for family members to set up trusts for. And so each of them did 4. And so they got, on top of their own, $10 million benefit, they got 40 million from each of, these 4 trusts. So it can be really powerful planning for sure.
Especially if you think about you're in a state that doesn't have, that it qualifies for, right? You're avoiding 23.8% between federal net investment tax plus, let's say, 5 to 7 on state. So 30% on $40 million is a big difference in what you take home. Obviously, the planning still comes down to like, don't move too much out of your name that you can't live your life and have that, but utilize the tools, because saving 30% is a pretty decent amount.
Yeah, for sure. Importantly, because I mentioned that income tax planning versus estate tax, you can actually do estate tax planning too with, a trust that's set up for QSBS purposes. So the idea there, just like that GRAT that creates like further trusts that are dynasty trusts, you can just set up your QSBS trust from the get-go to be a dynasty trust. So think that startup founder, setting up a $20 million trust for their kid, that would be, ideally set up as a dynasty trust to begin with.
Yeah. And I think you hit on some interesting points here, like on the tax trust rates. And so like we do still have to distinguish, right? Like the tax trust rates are going to be higher and they're going to scale faster than, for me as an individual person. But then the other downside too, right, is you're not going to get step up in cost basis by utilizing these. But at the same time, you are going to get all of the growth to be outside of your taxable estate.
Exactly. So again, comes down to doing some analyses with numbers and modeling with a financial advisor, an attorney, a CPA.
Totally. Okay. What's next? Going through some of the legal terms for us to look through?
Let's do it. Okay. Yeah, absolutely. And if you have any questions, by the way, with some of the trust names that we've just mentioned, feel free to ask questions, and to let us know that you want to hear an episode dedicated on, any given of these strategies that we're touching on. So in terms of some of the legal terms to look for in your trust, I think at a baseline, you just need to have an estate planner, a lawyer, make sure that for whatever the objective was that you formed the irrevocable trust to own your business interests, that those legal terms are in there. But beyond that, you need to have the trustee have the power to continue running the business. The reason why, and there's a slew of provisions that kind of comes in that package that I just mentioned, it's like that ability to continue and running the business. It's because under default state laws, your trustee has fiduciary duties. These are heightened duties towards the beneficiary to basically do everything in their best interests. And one of those duties, and they break down into all sorts of, different topics, but one of them is the prudent investor rule, right? So your trustee, one of its many, many responsibilities is to invest the assets in a prudent way. And so think of diversification rules, not holding particularly concentrated stock positions, particularly if that stock is very volatile, for example. And so you want your trust to override the prudent investor rule. And so whenever I had clients that brought in, specifically was doing planning around a business, you just have to make sure that there's a robust package of legal provisions so that your trustee is not all of a sudden, being potentially liable to beneficiaries because they're holding on to that business, right? The whole point is that you want the business in that trust and not to have the trustee sell off pieces of it. The second thing is you might want to consider bifurcating or separating the family financial matters from kind of the operation of the business, right? And you may have specific provisions that specifically address the business. And so this is where, let's say the reason why you put your business interests is for control purposes. You think that, your surviving spouse is going to, you want them to enjoy the economic rights, but not necessarily the control of the business. This is where you might say, hey, I need one trustee that's about like making sure my loved ones are okay, making distributions according to their needs. But really, when it comes to running the business and investing the business stock, I need, somebody who's closer to me and closer to that business. So let's say a business partner or somebody like that. So I don't know, Thomas, if you've seen that, but I think of it almost as embedding a voting trust, like a business voting trust within your like estate planning documents.
Yeah, that makes sense. I feel like you definitely would want to have those. Maybe not all the time, but most times you probably do want to have two different people in those different roles.
Yeah, it depends a little bit on, how involved you are in the operation of your business, right? Are you just an employee who happens to have stock that's like kind of indirectly like appreciating because of your efforts versus like you are, the president of this company. Yeah. Like I had, a client who was like running nursing homes, in California, and he very clearly, it was him and his business partner, and his spouse had like nothing to do with the business, wouldn't even know how to begin. And so he very much like decided to divide the trustee role into two.
Yeah, that makes sense.
And then we come upon some, issues that have to do with the legal form that your business takes. So one of those is that your business is taxed as an S Corp. So if that is the structure you chose for, income tax reasons for your business, you just want to make sure that there are certain provisions in your document that allow the irrevocable trust that will currently or eventually own your S Corp stock to be able to be structured as an S Corp owner. So there are specific rules that apply to trusts owning S Corp stock. And those would be, they're called like SBIT and QSST. So this is the electing small business trusts, and then the qualified subchapter S trusts. There are two different roads that you can walk down. There will be income tax considerations and other things for which road you might pick, but you just want to give your trustee the ability to pick a road that makes sense for that situation. So I would just make sure that the words like SBIT and QSST like show up in the trust. So that way you have that flexibility to continue running that business as an S Corp.
So question for you on that. So like with C Corp, you're owning stock, obviously it makes sense if you hold an irrevocable trust that like, hey, you own the ownership, there's not as much, but with an S Corp being a pass-through entity and that flowing through to your own tax return, does that mean that trust is paying those income taxes in that situation? Most people in that situation, right, are probably going to be in the highest brackets anyways. What's the difference? You just need to make sure you have the ability to pay it from the trust.
Right. So in an earlier episode, we mentioned this idea of like a grantor trust and compressed trust brackets. So this is kind of what we're talking about here again. So as a refresher, it's that you can either have the trust pay income taxes, and its brackets are going to be very different, or you can have some sort of individual pay the income taxes. And so if you are the grantor, so at that point, you would pay the income taxes for the trust at your own individual tax bracket rates. But if you're not around to be the grantor anymore, you've passed away, or in the QSBS context, you've actually specifically structured the trust to be non-grantor, then the only way to kind of get away from the trust paying its own income taxes is to pass things to the beneficiary, pretty much. So that this is where, if the beneficiary receives distributions, then the trust can take a deduction for those amounts because the beneficiary, Uncle Sam gets their dollars from, or his dollars from the beneficiary. So there are certain income tax planning strategies around that, but you just want to be aware that yes, the trust with a C Corp or any sort of structure where their income tax is coming up from the business or income coming up from the business, you'll have to figure out who pays the taxes on that.
Okay, that's helpful. Anything else left to hit on?
I feel like, Thomas, you presented an interesting question to me earlier this week where you had a client who was just thrown in for a loop, you guys had a wonderful plan to do some estate tax planning or whatnot. And all of a sudden it was like the company threw a hurdle, in your, Do you want to talk a little bit about that? And
without obviously going into too much detail, basically I have a client who works at used to work at a great private company, one of the early, high level people. And in the last, 5 years, the company stock has absolutely taken off. Even in the last 1 year, share prices went up like 25%. And so it went from a point where hey, when they got this stock a really long time ago, they set up a revocable trust. They live in California. They have everything in their revocable trust. So things are pretty good. But then in the last 5 years, they went from hey, we're worth a few million to now we're worth 20 million. And we're in our low 40s, don't plan to retire early, has a bunch of private investments. So in all likelihood, wealth is going to continue to go up. And to them, what's really important is they have younger kids. They grew up not very wealthy and they don't want to just turn their lifestyle into we're the richest people ever. We buy a $10 million house and all this. They want to keep it. They only want to spend on travel. And so estate taxes is something to worry about just because, they're at 20 million now. They might be at 25 to 30 million next year. The company they're at is very, very valuable. And it's, just continuing to dominate. When you're thinking about estate taxes, that was one of the big reasons that, we started to work together. And they reached out to their company and their company said, hey, you can't move this to any other trust because you already did it. We only allow one per person because they said there's some rule that after 500 entities own the company, they have to go public. We don't know if that's true or not. I mean, you and I have been talking about this. It didn't seem like it. And when I looked it up, there's all these weird things that basically says there's no shareholder limits in a C Corp. However, once the company has 10 million in assets and 500 shareholders, it's required to register with the SEC. This company has billions in assets. So I don't really know what they're talking about. So we can go into detail on this and talk more. But I think one is a lot of my clients get really bad information from their companies. So I always go to a bunch of lawyers. I have some great lawyers I work with who specialize in this and just say have you ever heard of this? They said no. So, we're going to go back to the company and say can you give us documents or any proof of why this exists? Because this company is potentially going to go public in the next 3 to 5 years, continue to grow. We could wait till then, but just the amount of growth that's happened, we'd like to get growth out of their estate. And so obviously we're hoping we can get the answer and actually do some of this trust planning.
I think to me, the moral of the story, and I encounter this all the time working with clients and their companies is, the companies have their own internal policies. They have a legal department that has studied this issue. Your client is probably not the first person to approach the company with an idea, to transfer shares to their revocable trust, irrevocable trust, whatever it may be. And sometimes they just have blanket policies that apply to everyone just so they don't have to deal with it. And so their policy is just really draconian as a result, because it's not actually meeting the legal reason why there's a problem to the company. And so you kind of just have to be patient and work with the company and see how much leeway your employee, your client has with their own company. And then there are things that you can do, by employing a lawyer to then, make the company feel better. So hearkening back to something we talked about in the previous episode, you can actually sometimes make them feel comfortable by inserting provisions into your trust to say, we'll meet, all of these requirements the company is putting on their stock just to get the company comfortable to say yes and sign off on a transfer. And lastly, sometimes the company just won't let you transfer. They just have such, tight restrictions on transfers that the best thing that you can do is just doing a transfer on death beneficiary form if they allow you to do that. And that's
well, it is in the revocable trust, which is nice. So won't really have to worry about that for them. But the interesting thing is it is a big company. And so most companies of this size do allow you to sell on, some private markets, but they don't allow that. Like they can't even move them to donor advised funds. So it might be right. Like I can totally see it just being some special provision that I don't really understand why.
I mean, with a company like that, your client can't be the only person wanting to do something like this. So maybe with enough appeal, from the employee ranks, the company might just rethink its policies.
And then I'll write a really good thread on Twitter about it. And all of a sudden, all these high-level employees from that company is going to be reaching out to me to help them do this. That'll be perfect.
There you go. There you go. Business development.
Exactly. But okay, cool. This was a really fun episode. And thanks for joining me as always. And everybody, thank you for listening. Hope you guys get to watch both of these episodes. I think you'll learn a ton. I actually was just having an argument with somebody this week again about I don't have my business owned by the trust. And I said, I got an episode coming out in a few weeks. I'm not going to argue about this. You can hear from Anne herself. So hopefully these episodes are helpful for people. And again, please rate, subscribe, and we'll see you back for the next episode.